Ma'am, we are live now. You can start.
Good morning to all. As you all know that 27th October to 2nd November was observed as Vigilance Awareness Week with the theme Satark Bharat, Smriddh Bharat. MOES and its various offices had arranged a series of activities like debates, painting competition, lectures, etc. to promote the theme and to create awareness amongst the officials and the public at large towards the policy of achieving transparency, accountability, and corruption-free governance. In continuation to that endeavor, we have invited Shri Akhtarul Hanif, Deputy Secretary, Ministry of Road, Transport and Highways, for a talk on vigilance mechanism and overview. Shri Hanif has worked in Ministry of Food and Public Administration, MCD, NDMC, Dudarshan, Ministry of Finance, where he has handled vigilance matters of Indian Revenue Services. He has also worked in the Office of Ministry of State Finance and presently working as Deputy Financial Advisor in Ministry of Road, Transport and Highways. He is also pursuing his doctoral degree in law. So the focus of his talk will be mostly on the rules, procedure and guidelines for dealing with vigilance matters and other important information which may be relevant to this topic. So I invite and request Sri Hanif to please start the lecture. Thank you.
Welcome all participants. It's nice to be here for me. Last week, unfortunately or fortunately, it was not done. Connectivity was lost. Anyway, we are der aaye durust aaye. My focus of discussion in vigilance is discussed with Mr. Paul shall be complaints. And on regarding complaints, nature, examination, CBC guidelines, non-vigilance cases, agreed list, and ODI list. If any person among audience is at any time, if some query is there, you may ask, interrupting me, so that that session will not be monotonous also, and I feel good that somebody listening sincerely. And then appointment of inquiry officers and duties of DA, etc. shall also be taken if time permits. And then examination of the disciplinary report by disciplinary authority, reference to CBC, quantum of punishment to be awarded to the charged officer. I would like to throw some light on these topics also. And then on retirement cases, some retirement cases are there in which you disciplinary authority intend to impose some penalty. Then I would like, of course, it is a big agenda today. It cannot be covered, but I will try. Then special procedure when inquiry cannot be conducted, Rule 19 of CSS, CCS, CCA, and importance of agreed list, ODI, instruction of the role of UPSC. I would like to throw some light on that. First of all, there are two rules of delivering justice in case of vigilance or any criminal case or somewhere. And these rules are principles of natural justice. First rule, nemo judex in causa sua. It literally means no one shall be judged in his own case. It means if somebody against some person complaint is coming to you, that complaint cannot be sent to the same person to take action, not at all. Therefore, no one shall be judged in his own cause. This is the first and foremost natural justice. All inquiry proceedings, constitutional provisions like 311 of our Article of Constitution of India, all around this nature of principal justice. Then second rule is odi ultram partem. Odi ultram partem means before imposing any penalty or taking any action against anybody, you have to hear the other side. It is must. If you are taking ex parte action, there should be sufficient ground or something like it is mentioned in the constitutional amendment, constitutional article 311 and also in CCA rules 19, that in case of security of state or criminal conviction, etc., then you can take the action so much. Then there are so many cases about principles of natural justice by various courts, including Supreme Courts of India. So natural justice principles have been upheld. One case, Savai Singh versus state. I will not go into the details. But one parameter is there. Extent of application of natural justice means nobody can be judged in his own case, and without hearing other side you cannot decide. There is limit. Somebody should not utilize or misutilize in the garb of natural justice and delay the proceedings and inquiries. Rule of law is to be held. I think all are knowing rule of law. Everything should be in accordance with the rules, procedure laid down therein. Then on the basis of principles of natural justice, our maker of the constitution, they have taken into consideration and introduced Article 311, especially for the civil servants who are working for the union or a state. This article you might be knowing or not knowing, I don't know. Dismissal, removal or reduction in the rank of person employed in civil capacities under a union or a state. It defines without giving natural justice means they have defined natural justice in different ways now. First point is no person can be removed, dismissed or any penalty can be imposed by the authority subordinate to which he was appointed. It means only appointing authority has the right to take action against the employee or superior to that authority. Nobody else. I think I'm clear. Somebody hearing? कोई hear नहीं कर रहा? All are mute. भाई सब भाग गए क्या?
Hello. Yes, sir.
Hearing?
Yes, sir. Yes.
I thought all are muted and I'm just lecturing one way. It's clear what I'm talking?
Yeah, there are participants. You can continue. So it is on YouTube. People can also listen to it later on. So
one point that to make it clear, any person cannot be penalized without the approval of appointing authority or superior to that. If authority junior to the authority who has appointed him or her cannot impose any penalty. I want to make it clear. Okay. Then second point, no such person in aforesaid shall be dismissed or removed or reduced in rank except after inquiry, in which it means due procedure is to be adopted. But there are restrictions. If somebody has been convicted on a criminal charge or it is not possible to conduct inquiry and the security of state is at stake, then disciplinary authority or appointing authority can take a view. Okay, the person will be penalized because inquiry is not feasible to be conducted, reasonable practical, and he has been convicted in a rape case, in murder case, or something, and security of state is either of three. If there is, then inquiry can be dispensed with. And inquiry practicable is or not that will be decided by the authority, who is disciplinary authority in his or her case. I think I am clear. Then complaint handling policy, that is very important, because generally complaint handling policy, authorities take a discretionary view. Discretionary means they go on whimsical and in a fancy way. Suppose some complaints come, investigate it. Your top boss will say, immediately investigate. That is not the way. There are two types of complaints. Number one, the complaints anonymous. It means without name. Now, DOPT instruction 18-10-2013 and further CVC instructions on that basis were issued. Anonymous complaints are to be filed. Complaint are to be filed. If complaint contain verifiable, the administrative may take cognizance of such complaint with the approval of complaint authority to be delegated as per distribution order in such cases. If second case is pseudonymous complaint. Pseudonymous complaint, name is there, but complaint name is there, but not verified. Then authority is required, competent authority required to ask the complainant within 15 days whether you are the same person, and they will take identity, either Aadhaar card or something. Okay. Then if nothing is heard, then again a reminder is sent. Then also nothing is heard, then it is simply filed. Facts may be verified or not, or truth or anything, but no action is required. If that person says, yes, I have complained, this is my Aadhaar number, then investigation can be made. This provision has been made because these complainants were misusing this at the time of promotion of highest officers like secretary, CVO. People are complaining, and then on the basis of that complaint, their promotion were held. No, because there is a complaint. Therefore, this complaint mechanism was set in by DOPT. I think all are clear. And in case of complaint against secretaries and equivalent officers, there is mechanism. All complaints are to be dealt by cabinet secretariat. There is a committee under security coordination in cabinet secretariat. Okay, this is in accordance with the DOPT instructions. Then I would like to throw some light on role of inquiry officers.
इंटरेक्शन not possible. अलग-अलग है connection.
क्या हुआ?
Please check the movement of the PPT. IATM.
Yes, ma'am.
The PPT is moving by itself.
Yes.
Please
Ma'am,
check.
I think they clicked on the enter button.
It is from there only.
Yes, ma'am.
Also, please check the PPT has to be started.
Anyway, I am going to inquiry. It has come directly to suspension. I don't know what happened. Okay.
Now you can go back to where you had left. Manually you can go back.
बार बार हुआ रिपीट हो रहा है ऊपर जाने से रिपीट anyway no issue no issue no issue. I was coming to the inquiry officer. Role of inquiry officers to collect all information regarding inquiry and to conduct in a fair and judicious manner. Number one, when disciplinary authority think inquiry is to be made against some official for some misconduct, a charge memo is drafted. And charge memo with the approval of disciplinary authority. Without approval of disciplinary authority, any charge memo is having no validity. This happened in case of income tax. So many cases, about 98 or 99 cases, they described the case on note sheet. And then they took the approval of the minister, that is disciplinary authority, Minister of Finance, for issuing the charge sheet. Draft charge sheet was not on the file. The concerned court, somebody went to the court, the charge sheet is not having the approval of the disciplinary authority. Charge sheet was quashed. Charge sheet has no validity. Therefore, any charge sheet to be served to the person, delinquent officer, is to be approved by the disciplinary authority or appointing authority. I think I'm clear. Number two, when charge sheet is served, then inquiry officer is appointed. Inquiry officer appointed. When inquiry officer appointed, inquiry officer should get charge sheet, charge memo, and 4 annexures. Number one, first annexure, the statement of charges. Number 2, statement of imputation. Number 3, statement of witness. I should go on.
Hello.
I am holding for some time. CBO ma'am has requested like this because of PPT presentation.
You can please go to from where your PPT is hanged, no, so that
Yes,
audience can understand. Yeah.
I am going from that point, ma'am, only.
We will display accordingly. We'll put that presentation properly accordingly.
Okay, I am going that way only.
Yeah.
Okay. Then I should go ahead.
No, let them put the presentation from where you left. The presentation is not moving.
Okay.
पद्माकर अपने तरफ से प्रेजेंटेशन डाल दीजिए.
हाँ. हाँ.
Again and again, same information.
So is it visible?
Yeah, but you have to link the slide mode in slide mode.
Okay.
Yeah. Now you can move to the point from where he left.
Please confirm which PPT is this?
Inquiry officer.
Inquiry officer, you can put.
It was, I think, Inquiry Rule 14.
So is this?
No, यही है आगे.
बस.
यही है.
हाँ, बस यहीं पे रख दीजिए. हाँ, ओके. आप कंटिन्यू कीजिए हनीफ साहब.
But I am not seeing, ma'am.
You cannot see. You keep it in your hand. आपको भी दिखना चाहिए. कैसे नहीं दिख रहा आपको?
मेरे को नहीं.
सर आप अपना शेयरिंग स्टॉप कीजिए, जो शेयर स्क्रीन बटन था उसको वापस से क्लिक कीजिए।
शेयर, हाँ ये स्टॉप शेयरिंग,
यस सर। सो नाउ यू कैन एबल टू सी।
देखता हूँ अभी ऊपर जाते हैं। नो, अगेन इट इज रिपीटिंग।
सर या नाउ क्लिक ऑन दैट IITM NOC
Yeah,
tab.
we can see you, sir.
Yes, yes, now it is going. Now it's okay. Now,
Only thing is display you can just make this role of yeah. Thank you so much.
procedure for conducting inquiry. I told you one thing: when inquiry is to be conducted, one charge memo is drafted, and charge memo should have approval of disciplinary authority or appointing authority, whichever is applicable case-to-case basis. The conduction of inquiry when charge memo is issued and inquiry officer appointed by disciplinary authority, inquiry officer should get 4 documents. Number 1, charge memo. Number 1, statement of charges. Number 2, imputation statement. Number 3, list of witnesses and relied upon documents. And 5th, after this, he should receive the defense statement of the concerned officer against the inquiry, against the charge. Okay, then he will start the preliminaries. The duty of inquiry officer to conduct the witnesses, recording evidence of both sides, prosecution and defense, examining the witnesses, examining chief. Examining chief is actually, unfortunately, the class is not interactive, but okay. Examination in chief is to examine the delinquent officer by PO, presenting officer. Okay. Then cross examination is done by defense. Techniques of cross examination main are, I would like to throw like, question should not be leading. It means the one question should not be loaded with answer of other questions. Suppose whether you are committed this misconduct, then the reply is yes or no. This is not the correct question, because if he says yes, then he is witnessing himself against him. Re-examination. Re-examination, there is a rule, CCA rule 14 within bracket 20. Re-examination or general examination is when all inquiry is done. Sorry, re-examination means in case anything left, then it can be re-examined, ordered by IO. Then I am coming to the general examination. General examination is when all inquiry is conducted, it is finished, then inquiry officer is supposed to ask delinquent officer whether anything has gone against you during the inquiry you have told yourself. Then he will say yes, then it is to be explained and is to be taken care of, because nobody can give evidence against himself. This is enshrined under rule 14 within bracket 20. If it is not done and he is a group A officer and for advice file goes to UPSC, they return to re-examine the case with proper inquiry from where the inquiry was finished. And in so many cases, inquiry runs years together. Inquiry officer retired or somebody is not traceable, then case goes haywire. Okay. Then one point, defense assistant is appointed, is proposed by defense, the delinquent officer. He should not be a legal officer until unless prosecution PO is legal officer. In general, it is not allowed. I think it is clear because time is less. When inquiry is finished, the report of inquiry under Rule 15(2) I am telling.
फिर वहीं पहुंच गए।
कैसे पीपीटी कैसे कर रहे हैं?
आपका ये जैसे आया है
नहीं ऐसा नहीं आया अभी। ऊपर नीचे करके करो।
15(2) है भी नहीं।
Okay. But I will explain. 15(2) is like this: when inquiry is conducted, an inquiry officer is finish his report and send it to discipline authority. That inquiry report with the views of discipline authority is sent to inquiry officer. If inquiry officer is agreeing to the the discipline authority is agreeing to the report, whatever inquiry officer has proved or not proved, then with his or her comments, it is to be sent to delinquent officer for his comments. Then only discipline authority takes into consideration.
People are asking. So once you tell me go to next slide, they'll go to the next slide.
I don't know if this slide is working properly.
Padmakar, can you go to the go forward with the slides?
Again,
Sir, please tell us the slide number.
You go ahead, please.
Go back.
Go back. Padmakar, are you listening?
I never famous. The last 3-4 days, I have delivered a few lectures in BSNL, in IREDA.
Padmakar,
very smooth.
Sir, please tell us the slide number.
You go back, no?
Yeah.
Go back.
We are going back.
Go back, please.
Phil?
It's not moving here.
Sir, it will not move there. The presentation is happening from here. Earlier it was happening from there. Now it is happening from here. So please tell us the slide number and say next slide, then we will move, sir.
And then now you go to back, no? Go back.
Slide number, sir.
Go back, please. Go back.
Slide number 30.
30, go.
So 30.
मैंने सबमिट कर दिया उठाओ में
आप करें आगे करें
सर ये ठीक है सर ये
सर यही है 30
This is talking about some room to be equal.
Go further now, 31. Go to 31.
Next.
Next slide.
15(2)
I can go without slide, no issue.
No, sir. People are here.
Go further.
They can take the copy of this slide.
Okay.
I can go. No issue. No. I can go without slide. No issue. Okay. All persons may take this presentation with them. No issue. They may copy or something. I will go. Actually,
you can send us these presentations, and if we'll send to all. There are a lot of participants who are listening to your lecture.
Okay. Now I was there. Inquiry report is to be sent to the delinquent officer with the comments of discipline authority. Okay. In case he is a group 2 officer, then the inquiry, the action is to be decided in consultation with the concerned CVO of the department and by the disciplinary authority taking a final view. In case of Group A officer where President is appointing authority, then it is mandatory to consult or to take the advice of UPSC. Then, where CVC comes. Now, at the latest instructions, if CVC has advised for imposition of major penalty and disciplinary authority is also of the view of major penalty, then they don't need, disciplinary authority don't need to send it back to CVC. They will send the case to UPSC. Okay, then one label is reduced. Then UPSC will advise. It is 320 or article of the Constitution, I think so. Then UPSC will advise accordingly. Disciplinary authority will take into consideration various facts of the case, inquiry report, views of the comments of the delinquent officer, comments of the inquiry officer, and the advice of UPSC. They will take decision to impose or not to impose any penalty on the delinquent officer. In case disciplinary authority decides not to accept the advice of UPSC, whether to impose the penalty or not to. Suppose the disciplinary authority has sent the file for taking advice for imposing the penalty, and UPSC advised no, there is no case made out. Then, if disciplinary authority is of a strong view, no, penalty is not to be imposed, then a disagreement or note is prepared by the disciplinary authority, very speaking every point, why he or she does not agree to it. Then this case is sent to DOPT. DOPT take a view, taking into consideration disciplinary authority views and UPSC advice. Then this is taken by DOPT. And in DOPT, the minister in charge, nowadays PM is in charge of that ministry, takes a view whether to impose penalty or not to impose the penalty. Okay, I think I'm clear. Instruction to Hanif. Next, this is done. Next, I would like throw some light on retirement cases. There is pension rules. Rule 9. Rule 9, if some person has been retired and it is made out that he has done some misconduct, then how? Because only pension is there. Then in this case, group A, B, C, D, 1, 2, 3, 4. No, nothing. Pension cannot be touched without the approval of the president. Therefore, all cases touching pension in which inquiry is to be conducted after retirement and pension is to be reduced or something, all cases become the case of UPSC. The inquiry officer report will similarly go to DA. DA will take a decision whether the penalty is to be imposed or not. Then he will take the advice of UPSC, and UPSC will decide the quantum of reduction of the penalty. Now, reduction of the pension. Reduction of the pension cannot be done below 9,000. Latest instructions, because 9,000 must for roti khane ke liye. This is the rule 9. But one thing more, if you are going to proceed against inquiry of a retired person, the time period is defined under the rules. You cannot take the action beyond 4 years. From the date of misconduct up to 4 years, you can take action. Beyond that, you cannot. Suppose a misconduct was committed by the officer in 1917, 1st January 2017. Okay, 2017. Then 18, 19, 20, 21. Up to 1st January 21, you can take action. After that date, you cannot. It is enshrined in pension rules, pension rule 9. I think I'm clear. Then I would like to throw some light for the point of view employees. This is about the chair on that side, with that vigilance setup, CVO and vigilance officer, UPSC advisor, all this. There is a rule 18. When you purchase some property, you are supposed movable properties of two kinds, movable and immovable. Movable property, car and something, laptop, computer, jewelry, like this. If it is more than twice your basic pay, you are supposed to inform the government. Okay? If it is less than that, no need to inform. Now come to movable property, immovable property. Immovable property like property, house, building, shop. Then in case you are dealing with a person, you are taking property from a person who is officially linked to you, you have to take prior permission from the government. Okay? If not, then you have to make intimation. I intend to purchase this property. This is intimated. Details may be furnished to them, to the authority concerned, within 1 month of the actual transaction. Okay. Second, if your wife is purchasing something out of her own salary, own expenses, all earning, then there is no need to inform the government. No need at all. If she is self-independent, no need to inform the government. Okay, this is the this has been given under Rule 18 Instructions Due. Two things clear. Then I want to throw on light one rule, that there is misconception who are drinking, whining, dining. Government servants are restricted to take wine, drinking in any public place. Then public place is defined any bar, any restaurant, any club. And you know everybody is taking. But if somebody go on rules, then he can be issued a charge memo for violating conduct rule. If even he is drinking in ISC, India Habitat Center, that is a public place. Court has defined like this: public place, any club is public place. But mostly we government servants are there. Therefore, if somebody is there, just I'm mentioning what is the rule position. Then second point, third, I'm coming for the point of the employees. Rule 16. Rule 16 of conduct rule. If you are making any investment in any company, like mutual fund or something, and you are dealing with that company or likely to deal with the company, okay, then you have to take prior permission of your employer, of the government. But is dealing and likely to deal in future. In Rule 16 of Conduct Rule, it is simply written dealing with or dealing in future. Suppose I have dealt that company 5 years back and I have invested in that company, then this rule is not applicable and no action can be taken. But I have seen a few cases in my vigilance experience Senior officers have been booked to make an investment in a company which they dealt in past. Ultimately, court has taken a different view. No, it is not applicable. From where? So generally, we are on this side of chair don't see the rules properly and apply them, on just preconceived notion. That in one of the charge sheet I was reading in the imputation, this officer may develop friendly terms this company and utilize later on after when he stopped dealing with them. These are our preconceived notions, and we should not take it. We should not mix with actual rule position. Rules are to be interpreted in terms of actual spirit they are framed by the legislature. If rule is saying dealing with or likely in future, then finish. Past, not at all. Then next I would like suspension. I'm very fast also. In case of suspension, same rule apply. A person can be suspended only by disciplinary authority, not less than that. Appointing authority or disciplinary authority, not less than that. And suspension is basically made to keep the officer off the duty in order to stop him from hindering or tampering the papers of contemplating inquiry against him in future. Therefore, no suspended officer is required to make attendance in office. He should not come to office at all. Number one. I have seen in some cases in field of office, because people are not aware of the rules, they order like this: he will come daily and make an attendance here, then he will go to home. This is not the way. Andhra Pradesh High Court has taken a grim view of this thing. A suspended officer cannot be ordered to sign and to come to office merely for signature, making attendance, because the primary aim of the suspension is to keep him off the duty of the office. Number two, suspension in case of conviction, or suppose somebody has have been detained in jail for more than 48 hours. Then what will happen? From the date he is deemed suspended. But suppose the concerned authority has come to the notice after 40 days, then, or after 90 days, then order will be like this: he is suspended with effect, deemed with effect of economic. But 3 months period of review of suspension shall be counted from the date of the order, because authority was not aware of that. Then in case of conviction, also there is deemed suspension. Now there are Supreme Court guidelines have come about suspension. Suspension cannot be extended beyond 3 months unless very cogent reasons are there. If charge sheet has not been issued within 3 months and suspension is to be extended, then there is speaking order. Otherwise, suspension should be revoked immediately. Second, if charge sheet has been issued, then there is no point of continuing suspension. These are the guidelines of Supreme Court, and in general, these are violated in every department every time. People are suspended and they are continuing 3 months, 6 months, 9 months. If somebody is going to the court, they can get the order. But court procedure is very cumbersome and very costly. So therefore, ultimately, the delinquent officer, likely to be delinquent officer, suffers. So authorities should take care of it. I request. Next. Then कोई point. Any point?
Penalties बता दो, major penalty, minor penalties.
Okay. Then in case Mr. Paul is requesting major penalty and minor penalty. In case of minor penalty, you know, there are 4: censure, reducing increment, and some major penalty: dismissal, removal of service, compulsory retirement, and reducing your rank from the higher rank to lower rank. The major penalty. In case of major penalty, the seriousness of the misconduct should be grave, like fraud, moral turpitude, then illegal gratification, pecuniary advantage. That's in case of minor penalty, the graveness of the misconduct is generally low. And one more thing, since if a charge sheet has been issued, then you can either exonerate the person or you can penalize the person. There is no midway. You cannot say. Generally, I have seen some officer who is not known to the generally vigilance officer in our Government of India, not thorough in the rules, because they have not dealt at the lower level or middle level. They are just coming at the top, and because rules and regulations are on the job, knowing on the job. If you are on the job for few years, you can. Even a CBO, when he is having 1 or 2 cases, no point. When he is having 100 or she is having 100 cases, there is chances of getting knowledge. And without that, it is not possible to do justice. Therefore, it is advisable to all CBOs that they should seek advantage of other officers who knows the law to decide the case. In case a person has been imposed penalty, issued charge sheet, either he or she has to be exonerated or is to be penalized. There is no midway. Mostly I have seen issue advisory, issue recordable warning. No, recordable warning is not a penalty. Therefore, either you exonerate or penalize. If you see minimum penalty is to be imposed, then you make a penalty of minor penalty censure. And it is not necessary that a penalty of a charge sheet of major penalty has been issued, then you have to impose major penalty. No, you can impose minor penalty also. After inquiry, disciplinary authority can take into consideration the details of the case. Oh no, it is not a very grave misconduct. It is simple case, censure may be issued, but no midway. I think questions will come later to me when I go to office in writing.
Interactive nahi, interactive nahi.
Session should be interactive. I have taken through a few sessions, all were interactive. I don't know, it is a very scientific department. It should be interactive. Then anything else you want to? Anything, ma'am, you want to ask me?
No, you first finish the lecture. Then if there are some questions received with the administration, they'll let you know. You can just finish your lecture, because I think by 1 we have to. So you maybe 5-10 minutes. Some questions are there. They'll refer.
Lecture is finished in 10 minutes or more. Okay.
Okay, you can finish the lecture first.
Okay, my lecture is finished now.
Okay.
PPTs are not moving. I am thanking to all for proper listening. Then I can answer any question on vigilance.
So, IITM, are there any questions you may please ask, and then we can just finish this lecture.
Sir, I have one question. This retired persons within 4 years, we have to take initiate that finish that disciplinary action, no, sir?
What? Initiate, not finish. Initiate.
Okay. Initiate that within 4 years, no, sir?
Suppose somebody is retiring today.
Okay.
And he has committed misconduct on 1st November.
Okay.
Then 4 years from 1st November up to 4 years, you can take action. Otherwise, not.
Okay.
Beyond 4 years, you cannot take action from the date of misconduct.
Okay. Sir, second question is that at the time, at the date of his retirement, that official, there was no charges against him. But after the date of retirement, charges were framed against him. So, what will be the course of action, sir?
Then, explain the question, please.
Sir, one official retired. Actually, some raid happened in our office.
Raid?
Yeah, on his date of retirement, the raid has happened. Then but the charge sheet was framed subsequently, means after a month or two. So on the date of his retirement, there was no charges against him, and even the initial charge sheet framed, his name was not there, but it was added subsequently.
Then okay, then action will be taken, no issue.
Within 4 years.
Within 4 years.
Okay.
Same applicable. But one thing, if these inquiry for departmental proceedings, not for criminal proceedings. Criminal proceedings are live anytime.
Okay, so once he is retired, then there is no this scope for any departmental procedure, no, sir?
No. If this is within 4 years, you can.
Okay.
Misconduct is within 4 years stipulated time. You can take action.
Thank you, sir. Thank you.
On the date of his retirement, there should be 3 things. There should be no charge sheet pending. He should not be under suspension, and there should be no court case and anywhere criminal case. Okay. Then his pensionary benefits, everything will be released as usual. Okay.
Okay.
Dr. Kamalji, this is Partha here. There is a question from YouTube. It is put in the chat box, but I can read it for.
Okay.
The question is, sir, can be evidence placed in PE be referred in a charge sheet as the list of documents? This is the question.
Question what? Please repeat.
Can be evidence placed in PE?
Preliminary inquiry.
Preliminary inquiry be referred in a charge sheet as list of documents.
List of documents is in general. All the documents on which inquiry is to be carried out. Therefore, preliminary inquiries should not be a derived upon document. Okay.
Any other questions? Okay, sir. Sir, one more question is there from YouTube.
Yeah, please.
Okay. This one, no? So the question is, how do we differentiate between departmental misconduct and criminal conduct?
Departmental misconduct is actually falls under the purview of conduct rules. Conduct rules 1964 applicable to central government or in various forms to various services, or India services and state government. If some misconduct is done under conduct rule, that is a departmental inquiry. Okay, and in case some criminal definition, criminal procedure, code of criminal procedure, that is criminal inquiry. Next.
Sir, one more question from.
Can you give some example, Hanif साहब? आप कुछ examples दे पाएंगे इसके लिए?
Example, suppose ma'am, some officer is accused of torturing his wife.
Okay.
And the case comes under domestic violence. It is a criminal case also. Okay?
Okay.
But similarly, under Conduct Rule 3, it is unbecoming of government. So simultaneously, departmental inquiry can also be started.
Okay. Thank you. Thank you. Yes.
So there is one more.
Then all criminal cases are misconduct under Rule 3.
Okay.
By murder, rape, anything, they are misconduct under Rule 3. And there is no bar in taking simultaneous action under department also and criminal.
So there is one more question from audience. Rule 19, in which case can an employee who has completed his or her sentences be eligible for re-employment?
It depends upon a disciplinary authority. Suppose a person has spitted on another person. Okay? He spitted on another person. It is a criminal offense and 3 months jail, suppose 1 month jail. Then he has completed his tenure. Then this is not such a thing that you can dismiss from the service.
He's talking about re-employment.
No, he is talking about re-employment after dismissal and after removal. How can a employee be re-employed? Under what conditions?
In case of dismissal, it is not.
The employed means, ma'am. The employed means
Can he be brought to service after dismissal and removal?
no, ma'am.
Is there any chance?
There are two things. There, the disciplinary authority to define in order. He is removed from the service.
Yeah.
Removal, I think removal is if he is removed from the service, removal or I'm confused now, but removal or either dismissal one, then he is not eligible to next employment. There is written in major penalty removal. Removal.
That's he is not eligible for next employment.
Removal. Okay.
So there is
removed from the service.
So one more question from audience. Any guidelines for using social media as freedom of expression?
My God. Very tricky question. But now you see rule 3 of conduct rule has been amended last 1 year, and they have made so many sub rules 1, 2, 3, 4, 5 up to 19 or 20. You can on social media you cannot criticize the policy of the government. Number 1. If anything on social media is connotation or is some sort of indication that you are criticizing a government or government policy, you are liable to be under this conduct rule. Okay. Therefore, I will advise avoid social media for commenting on government.
Thank you. Any more questions?
No, there is no further question in YouTube. So yeah.
So we will thank Hanif sir for this very useful and
come from you, ma'am. One question should come from you.
No, a lot of questions I have, so I cannot ask now. I'll call you sometimes. If you have time, you can come and guide us. Thank you so much. Thank you. So, Hanif sir, thank you so much. And there are a lot of participants who have listened to your lecture. I will request you to send us the presentation so that we can forward to all. And so thank you again for your really very useful and informative lecture.
Okay, thank you.